Hello everyone, welcome to the session on women and reproductive rights. The objectives of this lesson are firstly to examine the gender ratio in India and the various legislative measures sought to improve gender ratio such as the Prenatal Diagnostic Techniques Regulation and Prevention of Misuse Act 1994. Secondly, to examine the medical termination of pregnancy and surrogacy. Thirdly, to examine adoption under the CARA guidelines, and lastly, to evaluate the effectiveness of current legislative framework in promoting gender ratio and equality in the 21st century. Let's begin by looking at the gender ratio in India. May you be the mother of 100 sons is an old blessing bestowed on new brides across many parts of India. While one of the purposes of marriage is continuation of family, the stark emphasis on sons in the blessing outlines the social evils that plague women in India. It is this fascination for sons that has led to the terrible gender ratio in India and the root of many social evils like female feticide. It is now recognized internationally that parents have a basic human right to decide freely and responsibly on the number and spacing of children and a right to adequate education and information in this respect. There is no international covenant dedicated to reproductive rights. United Nations and various regional human rights instruments address reproductive rights as part of the broader covenants. The Convention on the Elimination of All Forms of Discrimination Against Women addresses reproductive rights under Article 12 and 16 and obligates the state parties to ensure access to health care services, including those related to family planning, and mentions appropriate services in connection with pregnancy and the right to decide on the number and spacing of children. Article 12 of the International Covenant on Economic, Social and Cultural Rights addresses the general right to the highest attainable standard of health by all. Female feticide is the single largest issue leading to the skewed gender ratio in many parts of India. The situation is so bad in some parts of India that there are villages full of young men and hardly a woman, which has led to a scarcity of brides for these young men. The census of 2011 showed that except for Kerala, no other major state had a sex ratio greater than 1000. During the period 2001 to 2011, the overall Indian sex ratio improved from 933 to 944. However, the child sex ratio deteriorated from 927 to 919. While the southern states showed a fairly higher sex ratio compared to the overall India, some of the northern states had sex ratio as low as 879. This shows that in spite of all the actions taken, the problem is enormous and requires urgent attention. Gender inequalities have persisted in India since centuries. Women and girls continue to be discriminated against at every stage of their life cycle. This manifests itself in the form of sex selection, infanticide, neglect, lack of access to health care, nutrition, early marriages, repeated and frequent pregnancies at a very young age, violence, etc. Sex selection, which is now assuming alarming proportions, is not a new phenomenon in India. Let's start with sex determination. Sex selection or determination. Biologically speaking, the female fetus is stronger and more adaptive than the male fetus, which is why there are more male miscarriages than female miscarriages. But strangely, in India, the number of girl children has been dropping alarmingly, and this has led to the absurd sex ratio discussed earlier. So, where are the missing girl children? Expanding scientific frontiers have brought in many medical techniques which assist doctors in determining the health of fetus, but sadly, these life-saving techniques are being misused to further female feticide. The first step in female feticide is the sex determination tests that medicine has now made easier and at a very low cost. Once the family becomes aware of the sex of the fetus, in as many as 5% of the Indian population, the fetus is sought to be aborted. So, the thought was to restrict the opportunity for knowing the sex of the fetus and thus removing one of the sources for female feticide. Injury to unborn child life is an offence under section 315 of IPC. This section makes an act done with intent to prevent the birth of a child or to cause it to die after birth punishable with imprisonment up to 10 years or with fine or both. Causing of death of an unborn child by an act amounting to culpable homicide is also punishable under section 316. Taking note of the gravity of the problem and realizing that one of the reasons for the disappearing girl child is female feticide, the Indian state enacted the Prenatal Diagnostic Techniques Regulation and Prevention of Misuse Act 1994. The PNDT Act was enacted to prevent the misuse of diagnostic techniques for sex determination leading to female feticide and for matters connected therewith or incidental thereto. The need for such a law was felt as the provisions under the IPC were inadequate to deal with new emerging types of female feticide. The PNDT Act under section 6 prohibits determination and disclosure of the sex of the fetus by any genetic counseling center or genetic laboratory or genetic clinic or by any individual. Any person who, including the woman, seeks the aid of such clinics, etc., for the purpose of determining the sex of the child is liable to imprisonment up to 3 years and fine up to 50,000 for the first offence and enhanced punishments on subsequent convictions. The PNDT Act also raises a presumption that the pregnant woman was compelled by her husband or other relatives to undergo prenatal diagnostic technique for knowing the gender of the fetus and punishes such person for abetment of offence under the PNDT Act. It aims to regulate the use of prenatal diagnostic techniques for detecting genetic or metabolic disorders or chromosomal abnormalities or certain congenital abnormalities. Due to the passage of time and development of new medical genetic techniques for sex selection and to plug the loopholes and inadequacies, the PNDT Act was amended in 2002 and the name of the Act was changed to Preconception and Prenatal Diagnostic Techniques Prohibition of Sex Selection Act 1994. Along with the earlier restrictions on diagnostic techniques, the Amendment Act prohibits sex selection before or after conception. The PNDT Act seeks to control both the sale of medical equipment to and the functioning of diagnostic and genetic medical diagnostic centers. The PNDT Act prohibits sale of ultrasound machines or imaging machine or scanner or any other equipment capable of detecting sex of fetus to any genetic counseling center, genetic laboratory, genetic clinic or any other person not registered under the Act. The Act also prohibits any person, including a specialist in the field of infertility, to conduct sex selection on any tissue, embryo, conceptus, fluid or gametes derived from any man or woman. The PNDT Act also prohibits any kind of advertisement relating to prenatal determination of sex and prescribes punishment for any contravention thereof. The Supreme Court is currently hearing a appeal in Sabo Matthew George versus Union of India, which was filed to stop internet search engines from showing up results related to prenatal sex determination. In this case, since the search results are technically not advertisements, by normal logic, it would be interesting to see what purposive construction the Supreme Court would give to the meaning of advertisement contained in Section 22 of the PNDT Act to address this issue. A central supervisory board is also constituted by the central government to create public awareness against the practice of preconception sex selection and prenatal determination of sex of the fetus. It is tasked with laying down a code of conduct to be observed by the genetic counseling centers, genetic laboratories and genetic clinics. All such centers shall be registered separately or jointly under the PNDT Act. The Supreme Court in Centre for Enquiry into Health and Allied Themes versus Union of India issued directions to the concerned authorities in monitoring the activities of the prenatal diagnostic clinics to prevent female feticide. The constitutional validity of the PNDT Act was challenged in Vijay Sharma and other versus Union of India before the High Court of Bombay, which dismissed the petition and directed the state to take all expeditious steps to prevent misuse of the diagnostic techniques. The facts of Gaurav Goyal versus State of Haryana reveal a classic example of total apathy and inaction on the part of state government in implementation of this significant legislation. Creating public awareness and elimination of feeling of insecurity and bias towards female child and stringent enforcement of law, sincere efforts of the government, etc., could provide a comprehensive answer in improving the sex ratio in India. Medical termination of pregnancy. No other issue hits at the root of women's rights than termination of pregnancy. Should the women not have absolute rights over the decision to have a child or abort? It brings forth rights of the unborn child and the debate on right to take life away even of the unborn fetus. All religions oppose feticide and assign varying rights to the fetus. Indian law of abortion is contained initially in the Indian Penal Code under sections 312 to 316 and subsequently in the Medical Termination of Pregnancy Act 1971. A person who aids and facilitates a miscarriage is liable for the abatement of the offence of miscarriage under section 312 read with section 109 of IPC even though abortion did not take place. The person is also liable for attempt to commit a criminal abortion under section 312 read with section 511 of the IPC even if he fails in his endeavour. For instance, in Queen versus Aruna Beva, where the term of pregnancy was almost complete and an attempted abortion resulted in the birth of the child, a conviction under section 312 was set aside and one under section 511 IPC for attempt to bring about miscarriage was maintained. The offender under IPC could be the woman herself or any other person. If the act is done in good faith to save the life of the woman, the person is entitled to the protection of law. Thus, IPC recognizes the fetus' right to life, but it is interesting to see the beneficial construction given by the Orissa High Court in Sharif versus State of Orissa, that where termination of pregnancy of a minor girl was performed to save the life of the mother, section 312 of the IPC is not attracted. To soften the rigors of IPC, the provisions in this regard, the Medical Termination of Pregnancy Act 1971 was enacted to provide for the termination of certain pregnancies by registered medical practitioners and for concerned matters. Section 3 of the MTP Act lays down conditions under which pregnancies may be terminated by registered medical practitioners. Such medical termination of pregnancy may not be an offence where the continuance of the pregnancy involves a risk to the life of the pregnant woman or of grave injury to her physical or mental health, considering her actual or reasonable foreseeable environment, or on diagnosis of any physical or mental abnormalities in the fetus, or where the pregnancy is caused by rape or is a result of failure of any family planning method or device. A pregnancy may be terminated by a registered medical practitioner before the 12th week and at times not later than 20th week of pregnancy. But there have been many cases where the courts have given specific permission to terminate the pregnancy even post the said 24 weeks. Incorporating section 313 of IPC, the MTP Act also prohibits termination of any pregnancy without the pregnant woman's consent. The consent of the guardian suffices in cases where the woman's age is less than 18 years or is a lunatic. All such medical termination procedure shall be conducted only at a hospital established or maintained or approved by government. The Act does not apply to a case where termination of pregnancy is not done in good faith to save the life of the pregnant woman. Termination of pregnancy by a person who is not a registered medical practitioner is punishable as prescribed under IPC. Any person who causes death while causing miscarriage is punishable under section 314 of IPC. The country has faced with a unique situation in 2009 when a mentally retarded orphan woman became pregnant due to rape by unknown persons. When the Chandigarh administration approached the High Court invoked the doctrine of parens patriae while exercising its writ jurisdiction to go beyond the literal interpretation of the statute and adopt a purposive approach. The same doctrine was used by the High Court to arrive at the conclusion that the termination of pregnancy would serve the best interests of the victim in the present case, even though she has not given her consent for the same. However, the Supreme Court refused to permit termination without her consent, as such termination was deemed not to be in her best interests. Adoption, an alternative to reproduction. Adoption is a natural extension of reproductive rights and may be required in a variety of circumstances. In the case of a single woman or man, widowed persons who may have lost their biological children, etc., it fills a gap that is caused by absence of biological child. Earlier, only the Hindus could adopt a child, as it was permitted by the Hindu religious texts and which was codified partially in the Hindu Adoption and Guardianship Act 1956. With the passage of Juvenile Justice, Care and Protection of Children Act 2015 and the adoption regulations framed thereunder by Central Adoption Resource Authority, adoption as a mechanism is open to all Indians irrespective of their religion or sex. The JJ Act grants the adopted child all rights that would be available to a natural biological child. It also permits a single woman to adopt any child of her choice. Under Rule 6 Clause 9 of CARA Guidelines 2011, an unmarried or single male person is not permitted to adopt a girl child. Rightfully, the JJ Act focuses solely on the welfare of the child in the adoption process, and the guidelines stress on the welfare of the child as paramount consideration in any adoption processed under the regulations. In a challenge to the adoption scheme under the Act of 2015, alleging that it violates the personal laws, the Supreme Court in Subham Hashmi versus Union of India held that, at the cost of repetition, we would like to say that an optional legislation that does not contain an unavoidable imperative cannot be stultified by principles of personal law, which, however, would always continue to govern any person who chooses to so submit himself until such time that the vision of a uniform civil code is achieved. Surrogacy, another alternative. Science is charting new territories, and surrogacy is one such area which is possible today solely because of the progress in medical science. Surrogacy is defined as a practice whereby one woman bears and gives birth to a child for an intending couple with the intention of handing over such child to the intending couple after the birth. This is a very recent phenomenon which throws moral, ethical, and legal questions not addressed before. What are the rights of a surrogate mother vis-a-vis the surrogate child? Can the surrogate child claim rights over the property of the surrogate mother? The current set of family laws have never contemplated such an event and are totally inadequate to address them. Surrogacy has also attracted a lot of negative publicity due to the alleged exploitation of poor women, cases of abandonment of the surrogate child by the foreign parents, refusal of visa by the foreign countries, etc. Anand in Gujarat has earned the nickname of Baby Factory and is the pioneer in commercial surrogacy in India. There are allegations that poor uneducated women are being exploited and used for renting of wombs. It is interesting to note that without a broad discussion on the rights of the surrogate, the proposed surrogacy bill seeks to abolish commercial surrogacy. In light of the newly emerging challenges with respect to surrogacy, a specific law on surrogacy may be expedited to protect the interests of surrogate mothers and childless couples as well. A few words to conclude the lesson. As noticed at various places in the discussion so far, the laws have tried to better the position of women in social domain. However, some of these protective legislations may actually be reinforcing the patriarchal stereotypes. For example, the proposed surrogacy bill, which seeks to prohibit commercial surrogacy altogether by trying to restrict the woman's liberty over her womb. The PNDT Act is an example of legislative attempt to address a social evil. It is another matter that the prohibitory approach adopted by the PNDT Act does nothing to change the basic social attitudes towards women, which are the root cause of the evil of female feticide. This brings the spotlight on the need for a review rhythm for updating the laws to reflect the changing needs of the society. Another aspect which is glaringly weak is enforcement of these legislations. The general compliance with laws in India per se is poor, and when it comes to laws addressing women's protection, the compliance rate is abysmally low. A strong endeavor needs to be made to ensure increased compliance. Thank you for joining us in this session. See you in next session. Thank you.